out of here a little bit early tonight.
Okay, we're learning about personal injury damages.
Okay, is that good?
Personal injury tort claims involve bodily injury to the person of the plaintiff, approximately resulting from the defendant's tortious conduct. Chapter 13 is the foreseeability limitation represented by proximate cause. This section examines the basic elements of personal injury damages. Damage rules for personal injury are independent of the basis of the claim. The focus is upon the plaintiff's condition without regard to whether the injuries resulted from a barroom fight or defective conduct. The tort may be based on negligence, strict liability, or intentional conduct. It is only with respect to punitive damages, Chapter 15, that the nature of the defendant's conduct affects personal injury recovery. The cases in the section concern the elements of damages for physical injuries. Not included are shock cases, such as the suits by accident bystanders who suffer injuries from watching tortious harm to loved ones. Chapter 14, distress. Even with physical consequences, is distinguished from physical harm. There is a distress component, however, in damages for physical harm. Recovery for bodily injury includes compensation for the plaintiff's physical pain and mental suffering. Pain and suffering are characterized as general damages in personal injury cases because bodily injury necessarily involves some degree of physical pain and suffering in order to present evidence of it. All other losses are considered special damages and require special pleading because they are the particular losses to each plaintiff. It is helpful to distinguish between past pretrial losses and future losses, if any. Elements of personal injury damages include loss of earnings or of earning capacity, medical expenses, pain and suffering, and special expenses attributable to the injury. Most states require future losses to be reduced to their present value. This topic is covered in the chapter immediately following this one, Chapter 12, concerning the use and value of money. A derivative action for loss of consortium with a personal injury victim is available for spouses. There is no uniformity among jurisdictions on the availability of consortium claims for other family relationships, such as for parents whose child is personally injured or for children whose parents have suffered personal injury. Loss of consortium should not be confused with other emotional intangibles such as grief or distress. Several state legislatures have enacted statutes affecting personal injury damages, especially in the area of medical malpractice. A common provision is to limit the dollar amount of the pain and suffering component. Some statutes alter the collateral source rule or limit the availability of punitive damages. Frankel versus U.S. From the Federal Supplement, Pennsylvania, 1970. As a result of an automobile accident with a car driven by an employee of the Department of Army, Marilyn Heim sustained a negligence suit against the United States pursuant to the Federal Tort Claims Act, seeking damages for her medical expenses and personal injuries. Cause of action, facts, and the rule is federal. The hospital medical bills to the time of trial totaled $17,325.69.
Maybe Professor Feller.
I will check with him.
Okay. And if he asks, you can give him my email. That's fine.
Okay.
Because the closest to what I'm looking at is the LA Library.
So I'm just gonna leave
for next fall.
Sorry. So hospital medical bills for this time of trial totaled $17,000. These expenses were fair, reasonable, and necessary for the treatment of her injuries. Under Pennsylvania law, her father is entitled to recover for the expenses incurred before she reached the age of 21. So that's state law. So those are the medical expense material facts and the state law as compared to this being a federal case. So at the time of the accident, Marilyn, born November 6, 1946, was 19 years of age, had completed 2 years of a 4-year course in commercial art at the Academy of Fine Arts in Philadelphia, and intended and was expected to continue to graduation, after which she intended to enter upon a career as a commercial artist. She did generally well in school and excelled in art. For the accident, she was normal, accident-free, and in good health, and enjoyed the usual activities of a person of her social and economic situation, including membership in the Girl Scouts, 4-H activities, and the like. She was an accomplished and well-known rider of horses and an instructress in all phases of horsemanship. Plaintiff claims past loss of brain capacity from shortly after the time Marilyn would have completed school, or July 1, 1968, to the time of the award. She would have been 21 years old. Age in July of 1968. The evidence showed that she would have completed school, and embarked on a career as a commercial artist. Her progress in school, her family background, and her paintings indicated that she was making excellent progress. The evidence convincingly demonstrated that she would have earned an average of $5,000 a year commencing July 1, 1968. Her earnings capacity to age 65 is $125,000, which, when reduced to present worth at 6% simple interest under the Pennsylvania rule, is $62,000, which will be awarded for this item. Okay. Present value of future cash flows. Other items of damage are physical and mental pain and suffering, loss of enjoyment of life's pleasures, inconvenience, disfigurement, and permanent injuries. The government argues that a large part of Marilyn's pain and suffering was not conscious because she was in a coma or semi-coma. Even while in a coma, she responded to painful stimuli. For many weeks when she was in a semi-coma, she recognized members of her family but could not communicate with them. During this time, she undoubtedly appreciated pain. In the future, she will experience pain from her arm, the use of the prosthesis, and from the therapy that she must undergo for the rest of her life. She frequently falls with a thud, making no attempt to break her fall. She is suffering and will continue to suffer mentally. She realizes that her sudden and uncontrollable outbursts are wrong, and she feels badly that she cannot explain her actions and apologize for them. In addition, she has lost the ability to engage in those activities which normally contribute to the enjoyment of life. The possibility of marriage and motherhood are gone. She cannot continue in the art career that she so enjoyed or engage in horseback riding. She has lost peace of mind and well-being. In short, she has lost almost every enjoyment that life can offer. An award of $650,000 will be made for these items. The final item of damage is what plaintiff has characterized as future hospitalization-related medical incidental expenses. Plaintiff contends that Marilyn is reasonably expected to live out her life expectancy of 54.7 years. She will need constant care for life, both physical and psychiatric. This care cannot be provided at home. Only one private institution, Fairmount Farm, near Marilyn's residence, is prepared to accept her and to render this care. And at the present rate of $75 a day, and taking into account projected increases, an award of at least $8 million should be made for this item. A much larger amount is requested if any part is taxable. While Marilyn is presently being maintained at home, there is no doubt that her parents will not be able to cope with her much longer, much less give her the physical and emotional therapy she needs. Fairmount Farm has 130 employees, including 40 nurses, aides, and attendants, servicing 114 patients. In addition, there are 50 doctors on the staff. If Marilyn were admitted to the hospital, she would have the individual attention and help she needs in her everyday activities, such as washing, dressing, bathing, and the like. While there is no hope for improvement in her mentality, emotional improvement is possible. This will require close individual attention. Public and most private institutions are not equipped to give this attention. Her program in these institutions would consist largely of sedation in an effort to control her outbursts. The medical testimony clearly shows that heavy sedation is not a proper course of treatment for Marilyn. There is no evidence that the regime in a public institution would be adequate, or of other private institutions, or of the comparative costs of private and public institutions. Plaintiff's claim for private institutional care is a proper item of damage. The government suggests that the temporary lump sum award should not be made because of the uncertainties in forecasting the cost of long-term institutional care and the large amount of money necessary to pay for this care. It suggests that the court ordered the government to establish a $500,000 trust fund under the control of a fiduciary, which would pay all the institutional costs, and that the court retain jurisdiction to resolve any questions of administration of the trust and order the government to replenish the corpus in the occasion should arise. Upon Maryland's death, the balance of the fund would revert to the United States. The common law provides for a simple lump sum judgment. There can be no judgment for an indefinite amount or a judgment payable in installments. The single lump sum judgment, as it relates to future damages, has been criticized. On the other hand, if the single recovery rule were discarded, final disposition of cases could be delayed for years, and the courts would have to assume the added burden of supervision of their awards. In ordinary cases involving private parties, there are physical considerations, practical considerations of insurance policy limits, and the ability of defendants to pay. Frequently, cases are settled or disposed for less than they are worth because of these. In Federal Tort Claims Act, actions of the ability of the government to pay is never in question. An amendment to the Federal Tort Claims Act to provide for periodic payments when future long-range damages are significant seems desirable. If such an amendment were passed, the government would pay much more in some cases and less in others than it would under a single recovery. In all cases, justice through just compensation, no more, no less, would be achieved. Such drastic changes must come from the Congress, however, and not from the courts. The government's suggestion is rejected. Plaintiff presented evidence that institutionalization costs have been increasing, and the cost of mental institution care in the Philadelphia area has increased by 5.25% each year over the past 10 years. Thus, plaintiff's original request for damages of $1,497,000, blah, 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 $75 a day, 365 days, $27,375 a year. For life expectancy, 54.7 years, this number becomes that number, $8 million, with the application of the factor for future cost increases. Inflationary considerations have most commonly been used in the justification of awards. In many instances, the consideration has been an evaluation of an award considering present inflationary trends as compared to awards in the past. The projected inflationary trend is speculation. Plaintiff has used the decades of 1960s, one of the more inflationary times in the history of our country. And the basis for the projection is over 50 years. It is common knowledge that our government is and has been attempting to control inflation, even to the point of considering wage and price controls. Economists differ on their predictions. Moreover, plaintiff will have money that can be invested, and if inflation continues, the return excuse me, this is over yet? Oh my god, so funny. On the money will be greater, and this will have offsetting effect. Increased costs for institutional care will not be considered. The government urges that an award for private institutional care must be reduced to present worth. Plaintiff relies on Yost versus West Penn Railways for the proposition that present worth does not apply to future medical expenses, and that the institutionalization required for Maryland falls in this category. And many of the costs which make up the daily rate of care and maintenance are not future medical expenses, but rather are custodial in nature. The Pennsylvania rule that future medical expenses are not reduced to present worth is based on a theory in Yost. Future medical attention presupposes an out-of-pocket expenditure by the plaintiff. She was entitled to have defendant presently place in her hands the money necessary to meet her future medical expenses as estimated by the jury based on the testimony heard, so that she will have it ready to lay out when service is rendered. Yost expresses a sound general rule, although the kind of medical attention to be rendered does not appear from the facts. It is usual case future medical expenses are sought to remedy a specific malady. If an accident victim will be required to undergo surgery, he would have that money to pay for the service if it is rendered shortly after the verdict. To apply the present worth rule to future medical expenses in most instances would necessitate the resolution of many collateral variable and imponderable factors, such as whether the victim intended to have medical attention immediately or whether the health would permit immediate treatment, and if not, when it would permit it. Clearly, there would be no workable way in which to apply the present worth rule. Here, the expenses of institutionalization will recur periodically in the same manner as future earnings and are payable periodically. If the rule of Yost were applied and the sum not reduced to present worth, plaintiff would have to pay money to lay out far before the services are rendered. Moreover, the return on any non-reduced sum properly invested would exceed the cost of the institutional care. Thus, Maryland would not only be compensated for institutionalization, she would reap a windfall. Damages means compensation for illegal injury sustained. The purpose of damages is not to make people wealthy. The general rule of Yost, as in this case with many general rules, must yield to exceptional circumstances. The award for institutionalization will be reduced to present worth. The amount so computed is $461,000, and it shows the calculation there.